All right. Welcome to the Novel Human Rights Crises During a Global Pandemic panel, sponsored by the ABILA International Human Rights Committee. We're very pleased to be here and to have you here. And the purpose of our panel is to discuss some of the unusual challenges to international human rights law that arise during global pandemics, with special focus on COVID-19. Pandemics already tend to exacerbate existing human rights problems in society because they put stress on existing institutions, they draw attention to existing social inequalities, and they pressure political elites to take urgent and sometimes extreme measures to slow the spread of the disease. In practice, urgent and extreme often means precipitous and ill-considered, with predictable consequences for human rights. In particular, the human right to healthcare tends to suffer when governments fail to prepare adequately to isolate the disease. And as always in a crisis, vulnerable populations suffer most. In most countries, that means imprisoned persons, indigenous peoples, immigrants and refugees, and disadvantaged minorities. But pandemics can also create relatively novel human rights problems. This panel will explore unique human rights challenges caused by pandemics. Due to our tight time restrictions, we will not have the opportunity to discuss all important novel human rights crises. Once we have for example, we're going to have to admit the effect on voting rights, which is very significant, especially in countries that have many political elites with a dubious commitment to democracy. Another is the effect on the right to freedom of assembly with its risks of contagion, and the human rights to life and health can be severely undermined when political elites withhold or misrepresent public health information in hopes of protecting their popularity. But enough about what we won't be discussing. Let's talk about what we can discuss. Please join me in welcoming our expert panelists. We'll be beginning with Professor Barbara Stark, Maurice A. Dean School of Law at Hofstra University. Professor Stark will address the effect of the pandemic on the human rights of children and on the right to education especially. We also have Professor Paul Dubinsky of Wayne State University School of Law and ABILA Vice President and Board of Directors. Professor Dubinsky will discuss how COVID-19 safety restrictions affect the human right to freedom of movement. And we have Christina Cerna, Adjunct Professor at Georgetown Law Center, ABILA Vice President and Board of Directors, and former Commissioner of the Inter-American Commission on Human Rights. Professor Cerna will discuss the relationship between COVID-19 and states of emergency as they're declared. After the presentations, we'll have a brief period of time for questions. And with that, I'll yield the floor to Professor Stark. Who will unmute herself with? Great.
Good afternoon. Here we go. The virus, the pandemic crisis has caused what, in the words of the human rights, the special rapporteur on the right to education says must be called an education crisis, grounded in the long-standing failure to build strong and resilient education systems and to fight entrenched inequalities, which picks up on what Aaron was talking about in the beginning. First, I'll just briefly describe the scope of the problem. Then I will discuss the specific dangers that the special rapporteur warns of and how they hit home, how they affect us. And finally, I'll conclude with the possible role of the United States in this dilemma, in this problem, facing this crisis. Okay. The lack of it was yesterday's New York Times had a full-page story saying that education is a top issue for parents, even if politicians haven't said so. And it's a top issue not just for parents, of course, but for children, and not just in the United States or among Times readership, but throughout the world. With different but astonishing, there are parallels between the the problems that people are facing here and in India and in Germany and in Switzerland and everywhere else. The reason it probably hasn't been reduced to sound bites or isn't part of the advertising budget of our politicians is that it's, as the special rapporteur notes, it has to be reduced to local quandaries. Every area where the schools have closed down, the problems have been different and particular. Some schools want more school choice. Some parents want the schools to be open regardless, and the schools to be assurances of safety. But in all of these situations, parents are concerned about the health and well-being of their children and their own need to get back to work and to feed those children and keep a house, keep a roof over their heads. Assessing the impact of the crisis, we have to keep in mind the underlying context. This is the scope of the problem part. Public education systems globally remain underfunded. Access to education is a dream for many. Inequalities in education are still striking. 250 million children and youth were already out of school before the pandemic, including children with disabilities. About 773 million persons today remain illiterate, many of whom are women living in lower income countries. The crisis has dramatically exacerbated already well-known issues regarding the implementation of the right to education. In particular, structural discrimination has dramatically showed its face during the education crisis, with the most marginalized and vulnerable groups being hit hardest. It is likely that the education crisis has affected more forcefully countries where public education systems are fragile. At the same time, as the special rapporteur urges, this is an opportunity to build back better after the pandemic and to address these past structural weaknesses. And let me just put out the suggestions, the major suggestions she has that I'll then try and apply in the remaining 7 minutes to the specific context that I'll be describing. First, she says, building back the right to education better includes fully integrating the rights of children, to whom the right of education is of special importance, and to our rights holders, who are not just passive recipients. Focusing on the most vulnerable as a matter of priority, placing the right to public education, not private education, at the very heart of educational policies. The numbers quickly become numbing. Let me tell you a story about what happened in India when the schools were closed. The virus closed the schools and the world's poorest children went to work. Children, as seen as described, journalists describe as seen in a public housing project on the outskirts of a city where children, a swarm of children appear, pour into the street in the morning. They're not going to school. They're not carrying backpacks or books. Each child instead carries a filthy plastic sack, which the child is going out to tour trash heaps and junkyards to see if he or she can find anything to bring back home that can be sold for recycling. Families are desperate for money. and children are an easy source of cheap labor. Child labor, however, is just one part of the looming global disaster. Severe hunger is stalking children from Afghanistan to South Sudan. Forced marriages for girls are rising across Africa and Asia, as is child trafficking. The right to education, all human rights are interrelated, as I think this panel will demonstrate. But the right to education is particularly concrete and particularly sharp, especially in the context of the pandemic. The right, for example, the right to education links to the right to water and sanitation, including in schools and other educational institutions. The right to adequate nutritious food when food is delivered through the schools, as it is in New York and as it is throughout the world. The right to adequate housing necessary to pursue homeschooling, the right to an adequate standard of living, and the right to work, which often depends on the level of education that people are able to attain, as well as the child's right to freedom from violence or injury or abuse. One of the major risks that the special rapporteur warns of is the risk of privatization, which is already a major factor in international education and in education in the United States. She warns, and this is Bolly Barry, is the special rapporteur. She warns that governments should consider the massive arrival of private actors through digital technology as a major danger for education systems and the right to education in the long terms. She refers to developing partnerships between states, intergovernmental organizations, and private actors, including Microsoft, Google, Facebook, Zoom, raising questions about the concrete participation of these actors in the field of education and the benefits that they obtain from such partnerships, whether in terms of public subsidies, collection of data, advertising towards children or youth. In the United States, similarly, privatization takes a different but related form. In the United States, almost 2 million children before the pandemic were homeschooled. Homeschooling, which is illegal in many countries throughout the world and regulated in most others, is wide open in the United States. Every state allows it. The privatization has been assisted in the United States by the participation of religious affiliated associations, which are mentioned in state laws. For example, in some states, a parent has to be a high school graduate in order to teach in a home school, but that requirement is waived if the parent is affiliated with the church group. The United States also doesn't, everything in the United States is left to the states to regulate. with respect to education, there's no federal right or enforceable federal standard. The only requirement is that it be adequate, which falls far below the standard under human rights law. American scholars have researched the texts that are relied upon for this booming homeschooling industry in the United States. They include statements such as Noah's Ark actually existed, that the earth is 15,000 years old, and other statements that are presented as fact to American children. America, however, as you probably know, is uniquely disqualified to suggest reforms on the international level because we are the only country in the world that has not ratified, that is not a party to the Convention on the Rights of the Child. So my main suggestion here is that we put our own house in order so that we're in a position to join the rest of the world in building education back better. In conclusion, the pandemic has undoubtedly changed the world. The United States, with more virus cases, more coronavirus cases and deaths than any other country, has learned the real costs of a lack of a national healthcare system. While the other wealthy countries have invested in healthcare infrastructure, the United States is winging it. We are also learning about the real costs of the lack of a national commitment to high quality education for all children. Unless you agree with the rather astonishing claim last night that we've turned a corner, the crisis is far from over. Too many children, too many American children lack healthcare, an adequate standard of living, and access to quality education. As the committee in charge of the administering the CRC, the Child's Convention, and every other country recognizes a country's children are its future. Committing wholeheartedly to their well-being is a matter of our collective survival. Thank you.
Thanks very much, Barbara, for that. And we're gonna keep our rapid rhythm going, moving on to Paul Dubinsky. Paul?
Okay, can you guys hear me now? Thank you, Aaron. First, let me say thank you to the American branch. I've been attending these for many years, and the branch did an amazing job in adjusting and adapting to a Zoom conference, and an exciting Zoom conference, which in many ways has the content we normally deliver in person. So thank you to the branch, and thank you to the committee for this opportunity to speak. I'm going to talk about the impact of pandemics and COVID-19 in particular on the free movement of people. That the free movement of people impacts so many other rights, particularly rights in the International Covenant on Civil and Political Rights. And let me here refer to what Barbara just mentioned. Free movement implicates the freedom to obtain an education, the ability to obtain medical care, employment, and so many other rights. For that reason, it occupies Article 12 of the International Covenant on Civil and Political Rights. And let me start with what my thesis is going to be, and then the order in which I'm going to attempt to tackle it. My thesis is in this country's and the global adaptation to COVID-19, there's been a good deal written and a good deal of attention paid to international travel. There's been far too little attention paid to travel within member countries. So for example, within the United States is one example, China's another. The American people have gotten sort of accustomed and acceptable to quarantines that restrict citizens and others lawfully present in the United States from moving to other states. And the prospect of international, of state-to-state retaliation, and also the rights implicated by that. What most Americans and others don't understand is those limitations are, for the most part, not the least restrictive available, and are in that respect both contrary to international treaty law, I'll address first, and second, US constitutional law. From there, I will talk about and quote from the two key articles of the International Covenant, and that is Article 12 and then Article 4, which is the state of emergency provision, and integrated into that analysis key guidance from the UN Human Rights Council. Finally, I'll conclude by recommendations as to what can be done to bring a reaction to freedom of movement of people into compliance with the treaty, into compliance with US law, and mention at the end the need for the United States in its next periodic human rights report to the UN to report everything it's been doing. And among all the other responsibilities of the executive branch, whoever turns to be the head of it in another month's time or so, reporting those to the UN will be incredibly important, along with other countries, for our guidance in the future. Okay, so let me talk about first the International Covenant on Civil and Political Rights. The United States is a party to that treaty, and with important reservations, understandings, and declarations. The most important of these is the declaration that the treaty is not self-executing within the United States, which means it's an international obligation of the United States. It will not, in general, be applied by US courts without implementing legislation. There is some implementing legislation. There was some pre-implementation. Okay, I'll be talking mostly about it as an international obligation of the United States. Second, the declaration of the United States of the Senate in ratifying the treaty that suggests that states ought to be more protective of the right to free movement of people than the treaty provides. If I can, for a second, pull up the respective language of the treaty. So let me say this. There it is. Okay, so the International Covenant has two relevant provisions. A lot of attention is paid to Article 4, which is the state of emergency provision, to the exclusion of Article 12 itself. The point I'm going to make is that Article 12 has limitations, and those limitations are the first level of what any state can do to limit the free movement of people within a country. Those need to be addressed, and far too much attention has been paid to Article 4. So let me quickly summarize the main provisions of Article 12. Article 12 says, 1, everyone lawfully within the territory of a state shall, within that territory, have the right to liberty of movement and freedom to choose its residence. The above mentioned rights shall not be subject to any restrictions except those which are provided by law, are necessary to protect national security, public order, public health, or morals, or the rights and freedom of others, and are consistent with the other rights recognized in the present government. The first thing to note about that is it applies to movement within the territory of a state party. And that freedom of movement includes not only the movement for temporary purposes, but the movement to change the domicile. The next is what kinds of exceptions cannot be justified or can be justified. And the first is to protect national security. The second is to protect public order. The third is public health or morals. And the final one is the right to freedom of others. Okay, the one most often referred to is the right to protect public health. And that seems really simple. It seems to apply to this case. I would argue it does not, okay, in terms of what most states are doing. The relevant meaning of public health under Article 12 of the treaty is the public health of the country, okay, not the public health of a component part of a country. So before I go to Article 4, I wanted to discuss some of the measures that are being implemented on a state-by-state basis within the United States. I guess the most relevant to refer to currently are the executive order and Department of Health regulations of the state of New York. Those regulations empower the department to identify states, other states in the United States with high levels of pandemic infection and positive test rates. Such people are barred from entering into New York unless they have submitted to a quarantine of 2 weeks' time. That quarantine has to take place within New York, okay? The justification that New York has given to that is essentially it's attempting to protect the health of New Yorkers or people within the state. And its rationale is that people coming from high infection states raise the risk of people in New York. In other words, it protects the public health of the people of New York. Unfortunately, under Article 12 of the ICCPR, that is not an adequate justification. Article 12 addresses the public health of a state party, and there's no reason to believe that restricting people coming from Michigan from entering into New York will improve or protect the public health of the country as a whole. In fact, citizens of Michigan who stay in Michigan are just as likely to add to the pandemic in their connection or in their exposure to other people in Michigan as they are in New York, okay? So that's the first main point about how the Article 12 justification is not satisfied by most state regulation in the US. I would add that the quarantine placed upon the entire city of Wuhan in China was similarly suspect under Article 12. That said, there's a fallback provision with additional justifications, and that is in Article 4 of the committee. I will briefly summarize that and explain why that also does not apply. It says, in time of public emergency which threatens the life of the nation and the existence of which is officially proclaimed, the state parties to the present covenant may take measures derogating from their obligations under the present covenant to the extent strictly required by the exigencies of the situation, provided that some measures are not inconsistent with obligations under international law. The key word here is a public emergency that threatens the life of the nation. What the covenant means in that context is not threatens the lives of many people in a nation, because Article 4 addresses extraordinarily dangerous measures. Those measures are declaration of states of emergency. Article 4 is the last resort, primarily because once states of emergencies are declared, they have the nasty habit of persisting long beyond the need for the emergency. Commentaries and guidance by the Human Rights Council, which in my opinion is wise and justified, makes clear that a threat to the life of the nation concerns the existence of the nation, the independence of a nation, and specifically even an armed conflict in which the nation is embroiled in is not necessarily a threat to the life of the nation. Therefore, the measures imposed, the permission employed by Article 4 does not comply with what many states are doing. Many states are restricting internal movement of people when their sovereignty and their existence is not at all at stake. What's wrong with that? Well, the right to free movement, as I mentioned, implicates so many other rights. Currently in the United States, one of the most important rights that can be infringed as a result of that is the right to peaceable protest. Okay, peaceable and effective protest in a country that is federally structured requires the ability of like-minded people in other parts of the country to join protests anywhere without restrictions. A prolonged restriction justified either under Article 12 or Article 4 of the Covenant, or comparable provisions that I'll mention under the US Constitution, greatly dilutes the effectiveness of protest. Okay, and as I assume all listeners are aware of now, we have months of protests under the Black Lives Matter movement and protests in connection with the 2020 election, right? Now let me move from the international to the domestic briefly. There's another condition on invocation of Article 12 and Article 4 exemptions, and that is under UN Council's guidance, which I also think is correct. Those have to be done by a country consistent with its own constitutional law and structure. In the case of the United States, then the covenant is essentially referring to the US Constitution, and the most relevant provision under the US Constitution is the Privileges and Immunities Clause. The Privileges and Immunities Clause, which was gutted so much by the Supreme Court in the 19th century, still retains a core to it that is very much alive, and that includes the free movement of people, of citizens from one state to another, and their ability to change their domicile, okay, to another state. It is my thesis that the current restrictions in place by states originally like Rhode Island and Florida, and now by New York, New Jersey, and Connecticut, are unjustified restrictions on the freedom of movement. And that is because the Privileges and Immunities Clause is a limit on what states may do. A necessity for further measures is up to the federal government. Okay, the Privileges and Immunities Clause is not a restriction on what the federal government can do. It's a restriction on what states can do. And there is a failure or an abdication of responsibility by the federal government. That is true. Some would say in the presence of such an abdication, states have to make their own way, and it's good policy for states to protect their citizens in this way. And I guess my answer is there are a lot of measures that are good policy. Some of them are simply unconstitutional. Okay, so what we're seeing currently, again with reference to the United States, is measures put in place that are essentially protectionist for that state, that are not the least restrictive measures available, are widely replicating themselves across the United States and are limiting vital rights such as the access to healthcare. So if healthcare facilities in ICU beds are in short supply in one state, a person from that state cannot avail themselves of healthcare and ICU beds in another state absent that quarantine. The last thing I'd say about that is quarantines necessarily disproportionately affect the free movement from one state to another. So, for example, if a New Yorker out of state wants to come back to New York State, that person must quarantine themselves, which means going out of state is heavily burdened in that sense. Okay, I guess the last thing I want to say about it is, what are least restrictive alternatives? Those least restrictive approaches present in the Supreme Court case law interpreting the Privileges and Immunities Clause and in the text of Article 4 of the ICCPR, okay? And those least restrictive alternatives in the case of the United States is the ability for out-of-staters to quarantine in their own state before entering in New York. Quarantining in their own state, okay, would substantially limit the burden on traveling to another state. Currently, the legislation in place or executive orders in place in many states that imposes quarantines requires quarantine in the state effective. Look at it from the point of view of an out-of-stater. They have to quarantine in another state where they may or may not have a place to live, which means they will have to stay in some temporary facility, perhaps a hotel, which is at extraordinary cost. Okay. That's a great disincentive to travel. And then there's one discriminatory effect, which I will end on. Some states, wisely in many respects, have enacted laws that provide medical leave for COVID infections, okay? And payment under, required employer payment under those circumstances. That means a New Yorker returning to New York will receive that benefit. An out-of-state party subject to quarantine will not. In closing, further research is needed in terms of in the United States and around the world as to how internal movement of people is being affected and just how bad that is. The last plug I want to put in is it's essential in the next US report to the Human Rights Council to detail all of the measures put into a place on a federal and importantly on a state basis and what their actual effect has been. Thank you.
Thanks, Paul. And we're gonna go immediately to Christina Cerna because we're running a little short on time. I see we're already getting some questions in, which we will address at the end. Christina?
Thank you, Aaron. And I'd also like to thank Aaron and the ABILA Human Rights Committee for organizing this panel and inviting me to be on it. And I'd like to encourage all the people watching to join the ABILA because it's a terrific organization. And then you can also become members of the Human Rights Committee. My topic overlaps a little bit with Paul's because he dealt with Article 12 and states of emergency, which is something I also plan to do. The first state of emergency in the United States was issued by Governor Inslee in Washington state, because that was where the first case in the US came up, on the 29th of February. On the 30th of January, the World Health Organization had designated COVID-19 a public health emergency of international concern, WHO's highest level of alarm. I'm gonna zip through this because I don't have a lot of time and I have a longer presentation than I have time for. But the initial states of emergencies were in Washington state, then in California, notably in New York. And then on the 13th of March, President Trump declared a national state of emergency. By mid-April, all 50 US states in the US were under a major disaster declaration for the first time in human history. On March 13th, on March 11th, the WHO declared COVID-19 a pandemic due to the growing number of people affected around the world. And on March 13th, President Trump issued a national state of emergency, which initially freed up to $50 billion in disaster relief funds, a sum that was multiplied many times over with the federal stimulus packages totaling approximately $3 trillion. Today, October 23rd, there are over 41 million COVID-19 cases throughout the world and over 1 million deaths, and no one knows when this crisis will end. The US, with approximately 8.4 million cases and over 223,000 deaths, has been the country most harmed by COVID in the world. China, where the virus originated, had only 91,000 cases, fewer than Honduras, and 4,700 deaths, primarily thanks to drastic measures taken early to stem the spread of the virus. In May, China reportedly feared a second outbreak after a cluster of 6 virus-infected people were identified, and it tested 11 million people in 10 days. India with 7.7 million cases, Brazil with 5.3, Russia with 1.4, Argentina, France, and Spain with just over 1 million are the countries, together with the US, that each has more than 1 million cases. And Colombia with 990,000 is not far behind. In international human rights law, human rights treaties allow states to opt out of some of their obligations when the state is in crisis. According to the UN Covenant on Civil and Political Rights, a state of emergency can be declared in case of public emergency which threatens the life of the nation, and the existence of which is officially proclaimed. Unlike the UN Covenant, the two principal regional human rights treaties, the American Convention and the European Convention, contemplate the declaration of a state of emergency during a situation of armed conflict. Article 15 of the European Convention proclaims that a state of emergency in time of war or other public emergency threatening the life of the nation. And Article 26 of the American Convention similarly states in time of war and threatens the independence or security of a state party. Since the UN Charter was premised on the international community's at least rhetorical abolition of war, it would have been inappropriate for the ICCPR to include war as one of the grounds for the declaration of a state of emergency. The invocation of a state of emergency allows states that are parties to the treaty to derogate from compliance with certain provisions of the treaty because of the emergency and until the emergency is over. As you see, there are four requisites. One, the crisis or danger must be actual or imminent. Its effects must involve the whole nation. The continuance of the organized life of the community must be threatened, and the crisis or danger must be exceptional in that the normal measures or restrictions are plainly inadequate. Some rights may not be derogated from. These are known as non-derogable rights, and the treaties identify them. In general, they are considered core rights on which all other rights depend. Different treaties consider different rights to be non-derogable, but there is an international consensus that four rights set forth in the European Convention are considered non-derogable by all human rights systems: the right to life, prohibition of torture, prohibition of slavery, and the right not to be condemned for under an ex post facto law. A state party to the ICCPR or to a regional human rights treaty regime that wishes to avail itself of the right of derogation during a state of emergency must inform the other states parties to the treaty by informing the Secretary General of the UN or of the regional bodies, the Council of Europe or the OAS in this situation. It must proclaim the emergency, provide the reasons for the derogation, the articles derogated from, and the expected duration of the emergency. It appears from the language of these treaties that the state of emergency provision was designed to deal with crises arising from a situation of armed conflict, a coup attempt, terrorism, or civil disturbance, because the emergency has to, quote, threaten the independence or security of the state, end quote. It has been suggested that mass immigration could also constitute such a crisis. A public health emergency on its face does not necessarily threaten the independence or security of a state, but the European Convention, for example, generally defers to the state's own assessment as to whether an emergency exists. States in general opt in favor of notifying the regional body rather than the United Nations of their state of emergency. In the Americas, 14 countries listed above have notified the OAS of a declaration of a state of emergency. However, there are 35 member states of the OAS, and Brazil, with over 5 million cases, is not on the list. Many European countries did not inform the Council of Europe when they invoked a state of emergency. 10 relatively newer members, those listed above, and the Council of Europe has 47 member states, these countries did notify the Secretary General of the Council of Europe. But the countries like the UK, France, Spain, Italy, etc., did not. And the European Court's jurisprudence specifies that a state's exercising a right of derogation is bound by a duty to notify the Secretary General of the Council of Europe. Otherwise, the derogation is not valid. President Macron of France in March even stated that France was at war with COVID, as the number of infected people doubled every 3 days. Macron said, and I quote, "We're not up against another army or another nation, but the enemy is right there, invisible, elusive, and it is making progress," end quote. Yet France was not one of the countries that notified the Council of Europe that it had declared a state of emergency. What France, Germany, the UK, and these other member states of the Council of Europe have done is unlink the declaration of a state of emergency from the act of derogation. This position is controversial because some countries argue that any country that declares a state of emergency, whether it makes a derogation or not, must notify the other state parties to the treaty by notification to the Secretary General. France, Germany, and the other countries that have declared argue that the measures that they have taken to prevent the spread of COVID can all be taken under the normal rules of the European Convention, and that there is no need to derogate under Article 15. They argue only if you derogate, you need to notify the regional body. So picking up on Paul's point of Article 12, for example, the right to freedom of movement, the right to freedom of movement may be subject to a restriction or limitation which is set forth in the article itself. The restriction must be provided by law and necessary to protect national security, public order, public health, or morals or the rights and freedoms of others. Restrictions on movement were issued pursuant to the European Convention as people were encouraged to shelter at home. People were instructed to cease non-essential travel, and the normal number of airline flights plummeted as tourism and business travel, et cetera, ground to a halt. I won't go into all of the other articles that have these public health provisions, but clearly Article 5.1e of the European Convention has a restriction to prevent infectious diseases. Interference with private and family life may be restricted for the protection of health. Freedom of thought, conscience, and religion, and freedom of expression may also be restricted for the protection of health. As the pandemic continues to complicate lives, opposition has developed to some governmental lockdown policies. In the US, this opposition has been encouraged by the president. One argument against governmental restrictions has been that the lockdown is causing drastic declines in the economy, that the cure is worse than the pandemic. One final human rights challenge, and I'll end with this, occurred recently in Michigan. On October 2nd, the Michigan State Supreme Court held Governor Whitmer's declaration of a state of emergency unconstitutional because the law pursuant to which the emergency had been declared was held to be an unlawful delegation of legislative power to the executive branch in violation of the Michigan Constitution. After 28 days, the governor declared the end of the state of emergency, but then redeclared a state of emergency and state of disaster under another law. The redeclaration of the state of emergency was also declared unconstitutional by the state Supreme Court. As a consequence, all of the executive orders issued by the governor pursuant to the emergency powers, requiring persons to wear masks, to maintain social distancing, closing restaurants, etc., all of these orders became void. Most seriously, 830,000 Michigan workers and their families could lose crucial unemployment benefits. It is too early to evaluate the harm done by the state Supreme Court decision. Attention, however, is focused on the 13 people who were charged with planning to kidnap the governor and to incite a civil war because they were upset with the coronavirus shutdown restrictions. but that is the subject for perhaps for a possible subsequent panel. Thank you.
Thanks very much. We're now going to go directly into the questions. We got about 9 minutes for questions, so we're going to take them in order, starting with Professor Stark. The Zoom chat question is, how does the right to education affect migrant and refugee children in a country with a residence visa or whose parents are on a work visa?
You've unmuted me. Thank you. Haven't you? Yes. That's an excellent question. It was addressed at some length in the report of the special rapporteur, and it's addressed in a paper that I hope will be forthcoming soon. These are one of the most vulnerable groups, refugee and immigrant children, and they have rights to education. They have rights not to be deported. They have rights not to be detained, not to be separated from their parents. It's an excellent question, and I think a human rights approach would prioritize their rights, would address the state to focus on remediating the obvious problems that they're going to have. I didn't mention this, but one of the most important parts of the right to education, in my view, is that it includes a right to human rights education. That is, part of the right to education is for children and everyone to learn about their own human rights and their entitlement. So the idea that the most vulnerable, that the children who are working for nothing or being trapped, how are they ever going to find out that their human rights are being violated or be in a position to do something about it? That, to Paul's point about any kind of effective political action. So thank you. That's a great question. Thank you.
Great. Our next question goes to Professor Dubinsky.
Yeah.
Okay, so are the travel restrictions that restrict external movement, such as people from other nations to visit their own people or to travel to other countries, consistent with international law, is the question.
Okay, two-part answer to that, which is the ICCPR Article 12 addresses mainly movement within a country. There is one provision, subsection 3, that turns about the right to leave a country. Okay, so measures that conflict with that are contrary to international law and that they're contrary to the covenant. The second thing I would say is what I've been talking about are international law within the context of this one treaty. Of course, other treaties come to bear, including treaties that govern political asylum and other matters. So there are restrictions on free movement internationally that are a product of other international treaties or regional instruments. Thank you.
Thanks. And then the third question is directed to Professor Cerna, which is, can one state invoke a claim against another state for violation of Article 12 of the ICCPR for applying international travel restrictions?
That's a good question. It's never been done. So there's no precedent for it. And the UN Human Rights Committee and also the regional bodies do permit interstate complaints. Whether it would succeed or not, I would have my doubts. But it's certainly conceivable. There are a lot of cases that are pending that do not prosper.
Yeah, states invoking claims against each other for human rights violations, pretty rare practice, just in general. It would usually take something much more massive and significant, I would think, right?
I would think, but you never know. I mean, it's these totally unpredictable kinds of cases that do manage to change the law. because somebody wants to change the law. And there is sympathy for it. And depending on how long this crisis goes on and how long airlines are being destroyed, who knows?
All right, Professor Stark, the next question is for you. It's what's the effect of forced marriages in India on the right to education, in your opinion?
Devastating. End of right to education, in my opinion, and the special rapporteur. Many people have spoken about forced marriages. Yes, they are not consistent with the right to education. The special rapporteur notes that this, I thought, was impressive, that based on data from the Ebola crisis, the early estimates were that 10 million girls who were taken out of school, whose schools closed, would not return. This was going to be a lifetime thing for them. You could never expect them to come back into any kind of education. But whether you can predict on the basis of one crisis to it, I don't know how valid that is.
All right, the next one I think is, I think either Professor Dubinsky or Professor Cerna can answer this one. It's, can state parties to the ICCPR limit freedom of movement under conditions of Article 12 and not resort to the state of emergency without invoking the state of emergency?
Yeah, I'd be happy to take that, because that was basically what I was trying to say, that these older members of the Council of Europe are interpreting the restriction on Article 12, the restriction on the freedom of movement, as something that does not require a derogation. So that means what they're saying is not that it's not a deprivation of the freedom of movement, which would be a derogation, but it's a restriction on the freedom of movement. And as I say, this is controversial. This is not universally accepted, that you can restrict without making a derogation under the state of emergency provision. But they are making these restrictions and not derogating, they say, and they invoke a state of emergency, but it's not in order to derogate.
It raises the question, I guess, and this is particularly appropriate for Professor Cerna, because she's chair of the ILA's Human Rights in Times of Emergency Committee, which is, if you can restrict freedom of movement so radically without derogating and declaring a state of emergency, why do we even need the ability to declare a state of emergency in the first place? Because in that case, we just say, well, the limitation is appropriate to the severity of the measure, and therefore we should always be able to restrict the human right.
Well, there is a state of emergency declared, but it is considered by these countries that the state of emergency provision is designed for countries in a situation of armed conflict or insurgency or civil disturbance of a much greater threat to the nation than a pandemic, which one would be able to, under regulations, somehow control. And so it turns it more into a manageable situation rather than a dramatic, life-threatening situation, or a nation-threatening situation. It's clearly life-threatening.
Pretty much, yeah, exactly the point Professor Dubinsky was making about whether the need to invoke a declaration and a derogation was appropriate in these circumstances. All right, that's all the time we have for.
Let me just say one thing on that, which is Article 4 is the only article that expressly refers to a temporal limitation. So it's implicit in our conception of a state of emergencies that they will be limited in time. Okay, there is no similar express statement in Article 12.
Right, good point. All right, everyone, please join ABILA through our website. Join the International Human Rights Committee if you're interested in human rights. And finally, join us at our mixer, which is happening immediately after this panel. Thank you all for coming, and thank you especially to the panelists for an enlightening presentation.
Thank you, Aaron.
Thank you, Aaron.
Thank you, Abdullah.